Hello and welcome to the program. I'm Shola Shuyeli. Last week on the show, we brought you some of the major highlights from the Justice Summit, which held in Abuja on January the 25th. A communique has now been released on how some of the recommendations from the summit will be implemented. To deepen the discussion on implementation, I spoke to a live bencher, the pioneer chairman of the NBA section on business law, George Etomi. He had a front row seat at the summit and participated actively in the discussions. I began by asking his views on practical suggestions for implementing some of the recommendations.
I must tell you I'm concerned because you cannot discuss a democracy without law and order. The rule of law is central to any democracy. But what we see today bothers me. With the sort of caseload, delays in our courts, I worry that more and more of our citizens will take the laws into their own hands if they feel they cannot get justice from the judiciary. And it concerns all aspects of our lives. Let's start with politics. The buzz now is politics. Everybody's so focused on 2023 politics. Now, the politicians themselves appear to be very helpless with regard to following rules that will enable them ensure that justice prevails even within their own political systems, which means that they are going to quarrel so bitterly they will all run to these same courts for adjudication. And our courts are not ready. I believe some time ago I spoke with you. I told you that the hierarchy in terms of prioritization for cases heard in courts is political cases, criminal cases, and then civil cases. You can't sustain that as a nation. You must get to that point where justice delivery is even across the board. So implementation is key. The NBA should set up a monitoring group, and we should begin to actively engage, if it is with the legislators, with regard to nailing this issue of whether or not the judiciary should be fiscally free, get a first line charge and all those things. Let them please do it and all that. You must go and get it done. If it is the executive we need to engage, we should do so. And to be honest with you, we are very blessed because the profession are well represented in these various arms of government. And I really don't think that we need to convince ourselves that the key to protecting this democracy actually lies in the legal profession. Judges do not become judges without becoming lawyers. It is the only arm of government where it's peopled exclusively by lawyers. And if we lawyers are not faithful to the rule of law, who else can do it? Politicians will quarrel, they will disagree. But if they know that if they come to the temple of justice, justice will be meted out, no matter whose act is God, they will settle a lot of their disputes before they come there. But right now, because there's this perception that everything goes, nobody attempts to settle disputes. You still have election cases that run from one election cycle to another. And because they are given priority, everything else suffers. Now, on the issue of the appointment of judges, there's absolutely no question in my mind that we will be better enriched if we begin to look at private practitioners who have been truly successful, who can go to our courts of superior records. And in this particular case, I would say the appeal court and the Supreme Court. Now, at the apex court, the Supreme Court, you are actually talking policy. You are talking law. Because, as you know, when the Supreme Court in the US begins to give pronouncements, everybody's on standstill. Because no matter what the legislature may have done, Congress may have done, executive may have done, everybody waits to hear from the Supreme Court. Because it is what they say that will define the shape of the law. That is the sort of Supreme Court we want. But today, because every single matter, every single complaint goes to the Supreme Court, they're overwhelmed, first and foremost. Secondly, the method of appointment is still this, it's like a promotion. You go from magistracy to high court to court of appeal and whatever. So at some point, you lose that ability for deep research, which you find many Supreme Court justices should have that background. They should be strong academics, strong advocates, whatever, with a deep-rooted sense of research. Because when they are going to make pronouncements, it must be very well considered.
But if we insist on this criteria, I'm not sure that a lot of our judges will remain on the bench.
Then that is sadly so. And if we go back, it is not as if it was always like this. In the past, it was very successful practitioners who were actually invited to the bench. They made you essentially convince you to leave your lucrative practice because they think you have the relevant cerebral matter to make a difference. Because you're talking about people who have control of life and death over people's lives. They must be deep thinking people. But sadly, over years, it's been eroded. A mixture of quota, favoritism, and all that has diluted that quality. And today, let me be honest with you, even with our senior advocates, how many senior advocates can you even convince today to leave practice to go to the bench? How many successful solicitors? How many even successful academics? And all that. And that brings me to this issue of the conditions of service, because I'm not blaming the judiciary. They too have to live within what they find themselves in. I do not understand why our judges are not well paid. First of all, in terms of aggregate, they are fewer in number than what the executives or legislators have to take care of. And as I told you, they are such a critical arm of the government in protecting our democracy. They must be insulated. Their retirement must be assured so that they can actually afford to leave their courts and go back home and not begin to look and worry about how their school fees for their children will be paid or how they can deal with other issues. So the conditions of service. And in any case, if you don't improve the conditions of service, you're not going to get the successful practitioners that I'm talking about leave lucrative practice to go to a bench.
Yeah, talking about conditions of service, I wanted to bring in technology and how it can aid the work of lawyers. I know there were extensive talks about all that too. How do we move to implementation in that area?
Yes, and I was saying that I feel sorry for our judges because part of the problem is that because we're all caught in this quagmire, we do not have judges who are readily amenable to modern processes. Many of them are still challenged technologically. Our courts should be digitized. If anything else, COVID has taught us that life is not going to remain the same. So if we don't move the judiciary to a digitized world, we're going to be slow, we're going to be left behind. Today, I can tell you for free, many matters are adjudicated without the judges having to physically see the parties in court. It's just got to be that way. I still recall, in anticipation of keeping up with the modern trend, the Justice Zana committee that was set to look into this digitization of our courts, as far back as 2012, submitted its report. They were going to start, if you remember, 10 years ago, with legal mails for every lawyer, which was supposed to be the beginning of the process. 10 years after, where are we with the legal mails? How many lawyers? Every lawyer is actually supposed to have an email tied to the Supreme Court. How many do file? Because if you have that, then technically it's easy for you to file processes from your office without physically going to the court, because it then goes through the mail channel. There is a central server that processes all these things, and then you get the return mail and go. That was the dream. but it's not happening yet. He was at a summit and he gave a part of his report card, and he himself said that resistance to change is one of the biggest problems. Many of the judges are resisting change. That is, fear of the unknown is there. And then the status quo, those who have sort of doing very well under this sort of confusing circumstances do not want change. And so there's a need to sort of reorientate ourselves. Even when he said that in Borno, I believe Bayelsa and one other state, that they had adopted it, and most of them are now do e-filing and co. We made a little bit of fact-finding about it, and yes, they're doing it, but they're still carrying papers there. Yes, they're doing remittances, remitter payment, and all that, but it's not digitization in the proper sense. And Lagos State, where we would have expected, yes, exactly. So that resistance to change is still there, but we can't give it up. We can't give up. So in terms of implementation, just to go directly to your concern, we must sign on all attorneys generals, all governors, and I think each state should take it as their responsibility to digitize their judicial system. It is in everybody's interest that that is done, so that you can remove, as they say, 50% of the cause of delay, which is this question: I was served, I was not served, I didn't get it, I got it, I didn't. Look at what happened in the Supreme Court in the GT and innocent case. GT claimed they filed. It was not in the records. Supreme Court went ahead and gave judgment on the premise that GT had no defense to the matter, only for GT to prove that they filed, but somehow there was miscommunication between the court registry and the court. That's so embarrassing. That led them to reverse an earlier ruling they gave in the Imo State matter, that the Supreme Court was functus official once it's given a judgment. Now, in a spate of 2 years, how can we have at the apex court this sort of conflict in a legal principle? So where is stare decisis? We must understand the depth and the quagmire we find ourselves in. Some are human and need to be dealt with in that fashion. But those that are systemic, like this issue of digitization and co, will come over time. But the willingness to start that journey begins with me and you.
You also wanted us to talk about the role of lawyers. Now we're talking about all the challenges, and lawyers also have a big role to play.
Big role to play.
How should we be addressing this?
In fact, not just lawyers, but the senior lawyers. Because I am getting very troubled by the fact that we are quick to blame the judges, and many times the judges are unable to speak for themselves when the blame comes. But let us do a little bit of introspection. Who are those who ask for adjournments when they shouldn't? Who are those who make preliminary objections on mundane issues when they are not ready for trial? Date, everything is set, they go, they look for a technical point. Lawyers and senior lawyers. And this quest to become senior advocate, the criteria which says you must complete a certain number of cases, is also driving unnecessary congestion in our courts. And I begin to shudder when I see younger lawyers, junior lawyers, sustaining litigations. And what I mean by sustaining litigation, long after the client has lost interest, the lawyer sustains it because he must go towards completing to meet the criteria. So why don't we tweak the criteria and reward lawyers who are able to mediate and deal with matters with a result, because we must understand the purpose of litigation. It is to settle disputes. So if you find a system that rewards lawyers who actually meet and discuss and settle issues and make it a criteria for reward, you will see the phenomenal impact it will be on our caseload.